Hello, I am Dr. James Donnelly, and today I am accompanied by my esteemed colleagues, Dr. Esther Lammers and Dr. Tanisha Wong of the Australian Medical Association, more commonly known as the AMA. Today we'll be conducting an investigation onto the current state of legislation within the Queensland jurisdiction in regard to psychiatric harm within the medical workplace. To this day, the Queensland jurisdiction fails to conclusively cover and recognise claims of compensation in regard to psychiatric damage for an employee against their employer, in particular within the medical field. Given the high-strung environment all professions of the medical field continue to operate within to this day, calls of reform for claims in association to mental harm and injury continue to grow. The following presentation will focus on the three key areas of the current state of liability, policy and social effects, and lastly, recommendations and reformations to be made to the current legislation. State of liability. The current state of liability in regard to the workplace injury within Queensland is separated into three pieces of legislation: the Civil Liability Act, the WorkCover Queensland Act, and the Workers' Compensation and Rehabilitation Act. Although the Civil Liability Act defines personal injury to include A. a fatal injury, B. prenatal injury, C. and most importantly, the psychological or psychiatric injury, and lastly D. disease. For injuries in relation to psychiatric damage or harm, an individual is to rely upon the Workers' Compensation and Rehabilitation Act of Queensland. After the IP panel report, where statutory changes to common law actions were implemented across Australian jurisdiction, the Civil Liability Act was regarded to be the most relevant for personal injury claims within the jurisdiction. However, Section 5, subsection 1b of the CLA states for civil liability to be excluded if compensation is said to be payable under the Workers' Compensation and Rehabilitation Act. Firstly, in analysing the Workers' Compensation and Rehabilitation Act, the intention of the legislation is to provide fair and appropriate benefits for injured workers or dependents and persons other than workers. The Workers' Compensation and Rehabilitation Act provides this intention to protect employees against tortfeasors for breach of duty. However, as to be further elaborated upon, scope of liability in regard to psychiatric injury remains limited. Section 32. The meaning of injury. The meaning of injury within this Act will be of specific importance in addressing the state of liability, in particular subsections 1. How the term injury is to be defined. 3. What an injury includes. 4. Extent of aggravation. And 5. Exclusions to psychiatric injury. Subsection 1. How injury is to be defined. The term psychiatric injury is defined by Section 32, subsection 1b of the Workers' Compensation and Rehabilitation Act is considered. The term is straightforwardly defined within this legislation as an injury arising out of a psychiatric or psychological disorder by the employer is regarded to be the significant tortfeasor of the breach of duty against the employee. The absence of a clear and in-depth definition for the term injury in relation to mental harm within this Act offers a limited scope of the issue in comparison to neighbouring jurisdictions, such as the Civil Liability Act of 2002 of the New South Wales jurisdiction. The New South Wales jurisdiction, as shown upon the slide before you, offers a clear and concise definition for mental harm and broadens the scope of personal injury to include impairment of a person's mental condition. Furthermore, the Wrongs Act of 1958 of the Victorian jurisdiction continues to expand upon possible psychiatric injury through Section 23 of the legislation, stating that an action for injury to the plaintiff may proceed against the tortfeasor for breach of duty if the psychiatric injury arose from circumstances partly or wholly from mental or nervous shock. The circumstance for breach of duty remains absent from the Workers' Compensation and Rehabilitation Act and Civil Liability Act of Queensland. Although the latter of the two pieces of legislation attempts to broaden the scope of personal injury to incorporate psychiatric injury to its definition, it still fails to provide a clear scope for breach of duty of the employer in regard to mental harm. Following on, subsection 3(ba) broadens the scope of injury to include the aggravation of a psychiatric or psychological disorder, if said aggravation is to arise out of or in the course of employment. The employer will remain the significant tortfeasor of contribution to said aggravation. Subsection 4, however, begins to limit this scope of liability and access of compensation by stating that an aggravation of a psychological injury due to a breach of duty by the tortfeasor will only be an injury to the extent of said aggravation. The final subsection to be analysed is that of subsection 5(a) in particular, providing that an exclusion to subsections 1 and 3 of section 32 in regard to breach of duty by the employer. Upon the legislation, if the aggravation of a psychological disorder or injury stems from circumstances where management, i.e. the tortfeasor in this scenario, has taken reasonable action in relation to the plaintiff's employment, the liability of subsequent aggravation shall not be placed upon the employer, i.e. the tortfeasor. Examples of reasonable action performed by management include a demotion, or in reverse, failure to provide a promotion, disciplinary action to be taken against an employee, transfer of branch, or simply dismissal of an employee, as stated within subsection 5. Reasonable in theory, the decision held within the judgment of Collar and Cerebos establishes basis for subsection 5 of the legislation to remain flawed and questionable. In this case, the plaintiff's claim against the tortfeasor for breach of duty leading to psychiatric injury was rejected on the grounds that injury had arisen simply from duties the plaintiff had been contractually obligated to complete. The stress inflicted upon the plaintiff being demoted from their current position is something that nearly any reasonable person would suffer. Yet, maintaining the same demanding workload is understandable to do nothing but increase the stress of the employee. However, demotion was interpreted by the court to be reasonable in means of management by the tortfeasor, i.e. the employer, and thereby awarding exclusion of liability for the defendant. The application of this limited scope at common law was replicated in the judgment of Woolworths and Perrins. The judgment of Collar was interpreted to be the binding authority of duty for the duty of care owed to an employee by the employer in regard to the breach of duty leading to psychiatric injury. However, it did not extend to the mental harm suffered by undertaking obligations a party may contractually be obligated to complete. The limitation is further scrutinised within the medical field in particular. The limitation enforced by Section 32, subsection 5 of the Workers' Compensation and Rehabilitation Act is exemplified by the judgment of Hegarty and Queensland Ambulance Services. The Court of Appeal held at that time that it was reasonable for the plaintiff's supervisor, i.e. in this case as well the tortfeasor of the scenario, to treat the complaints it demands as a claim for simple improvement of working conditions made by the plaintiff, rather than an indication of the plaintiff's possible deteriorating mental state. This scenario was deemed to be beyond the scope of liability in relation to the duty of care owed to the plaintiff. The scope of application of Section 32, subsection 1b, fails to recognise the causation of the psychiatric injury upon the plaintiff to be in direct relation to negligence of duty by the defendant. Both precedential judgments made at common law and recognition of mental harm from the provided legislation leaves Queensland jurisdiction providing a limited scope of liability in relation to the claims regarding mental harm, therefore leading to the Australian Medical Association to be of the belief that reform is required within the state for the betterment of all parties involved. Next, my esteemed colleague, Dr. Esther Lammers, will continue with policy and social effects relevant to psychiatric damage within the workforce.
Hi, I'm Dr. Lammers, and my role at the AMA is to analyse the impacts on public policy and wider society and theoretical issues involved with the inefficiency of the current personal injury tort law regarding compensation for psychiatric injury in the workplace.
WorkCover Queensland is the exclusive provider of accident insurance for work-related injuries in Queensland, which provides wages and medical costs of employees.
For those who suffer a psychiatric injury during the course of their employment, the process for the claimant begins with a workers' compensation medical certificate for their injury, which may be difficult for those suffering unrecognised psychiatric harm. If attainable, the certificate must be produced to the employer before a claim is made with WorkCover Queensland. In determining liability for compensation, WorkCover Queensland apply criteria and exclusions as outlined in the Workers' Compensation and Rehabilitation Act 2013.
Although WorkCover Queensland concede that they compensate for critical events ranging from violent traumatic events to longer-term events such as bullying and excessive workload, the issue arises when, by WorkCover's compensation process, a claimant is assessed against the Workers' Compensation and Rehabilitation Act 2003. However, as outlined previously by my colleague, the limitation of scope for liability in the Act, as well as in common law, hinders the availability for injured workers to attain compensation.
There are theoretical issues concerned with the ability to compensate for psychiatric injury.
The economic theory is concerned with utilizing an economic method of cost-benefit analysis to determine tortuous principles.
In regard to psychiatric injury, the economic theory would suggest that payment of compensation is less than the cost of preventing the injury from occurring. However, a recent study conducted by WorkCover Western Australia analysed the workplace psychiatric injury compensation legislation in each jurisdiction and determined that there is effectively no long-term cost savings resulting from exclusionary provisions and limiting the scope of liability for psychiatric injury claims. Therefore, limiting liability for the injuries suffered by our medical staff is not effectively cost-reducing and benefit-enhancing. Feminist theories encourage tort law to develop in a way that demonstrates an ethic of care and concern for members of society, particularly vulnerable members of society. A national study conducted by Beyond Blue identified that junior doctors and female doctors appeared to have a higher level of general and specific mental health problems and reported greater work stress compared to their male counterparts.
In relation to psychiatric harm in the medical professions, Figures 1, 2, and 3 illustrate that the female doctors experience significantly more stress, depression, and suicidal ideation compared to men. 5% distress in males to 66% in females. 5% depression in males to 8.1% in females, and 22.3% suicidal ideation in men to 28.5% in females.
These graphs show that women are more susceptible to psychological effects of being a doctor compared to men. This would allow female doctors to be considered more vulnerable. Junior doctors are another vulnerable stakeholder in society, identified in the study as appeared to be particularly vulnerable to poor mental health and high levels of stress. Compared to older doctors 51 to 60 years, younger doctors reported higher rates of burnout. Across 3 domains of emotional exhaustion, 47.5% versus 21.1%, low professional efficacy, 17.6% versus 28.8%.
So you went through a real burnout, didn't you, in your 3rd year? Tell us what happened.
I just didn't feel emotion for about 6 months. No joy, no sadness, no stress. I was just emotionally kind of blunted. And it got to my 3rd year where I would come home and just cry for hours, and nothing would trigger it off. It would just happen. And I just got to a stage where I would look in the mirror and I would not recognise the 18-year-old who started medicine and the person I was in 3rd year. I was so different.
The Beyond Blue report also outlined the significant difference between the mental health of doctors compared to non-medical professions. In all 3 categories, distress, depression, and suicidal ideation were significantly higher in doctors compared to the Australian population and other professions. However, it is not only these doctors that are experiencing significantly higher levels of psychiatric stress compared to non-health counterparts. A 2016 study found that the suicide rate for female midwives and nurses is almost 3 times higher than women in non-health professions.
The suicide of a young female doctor in January this year has pushed for an investigation into the mental health of Australian medics. The family of the woman admit that it was the brutal and completely unsustainable expectations of her job which determined her fate. Health Minister Brad Hazzard acknowledges that it's not just doctors but all the medical staff, including nurses and paramedics. He says we need to understand the full breadth of the problem so that we can start putting evidence-based measures into place.
The failure of the Queensland legislation to comprehensively recognise the liability for psychiatric injury in the workplace filters down to the policies and procedures implemented within medical professions that deal with situations that may cause psychological distress. This is exemplified in the lack of procedures that aid medical staff in dealing with high-intensity events. The high-stress nature and culture of medical professions has seemed to create a burden to speaking out about psychological distress within the workplace.
Approximately 40% of doctors felt that medical professionals with a history of mental health disorders were perceived as less competent than their peers, and 48% felt that these doctors were less likely to be appointed compared to doctors without a history of mental health problems. Approximately 59% of doctors felt that being a patient causes embarrassment for a doctor.
Although there are procedures in place to deal with traumatic events, they are optional. And for example, in the Queensland Ambulance Service pre-course reading, there is a stress management section which reads, "The first aid provider may be invited or requested to participate in an incident debrief." However, WorkCover Queensland outlines in the current national guidelines to promote recovery after traumatic events that routine psychological debriefing is no longer recommended. An SBS Insight episode highlights the effect of insufficient implementation of policy and procedures regarding the effects of traumatic situations on medical staff in Queensland.
As a nurse, I certainly had lots of debriefing. At the end of every shift, we all walked out together. You'd say, we're all going to the pub, we're going to, talk about it. And if you'd had a really crap day, if your mates would say, tell us about it, and you'd all laugh, and you'd kind of say, we're here with you, we were there, and you get a very different perspective. Within medicine, you are by yourself a lot of the time, and even if you are trying to debrief with others, so often the response is, oh, you think you had a bad day, I had it worse. And you're competing even with how bad it is. So,
Hannah, is that what happens for you as a nurse? Do you get the debriefs after every shift with the other nurses?
Honestly, I am yet to have a debrief. And I think that is a workplace culture kind of thing, and that's it.
A discussion paper from the University of Queensland determined that there is a shortage in supply of medical staff in Australia. A national survey on the psychological health of medical staff determined that 17% of medical staff admitted that, given their time again, they would not have studied medicine due to the effects it has on their lives. This is concerning for policymakers considering Australia's increasing population. Australia's ageing population and expected tourism increase, which calls for a strong and reliable health system. If the amount of medical staff that is already in shortage further declines, there will be a significant burden on the healthcare system. Issues such as understaffing, increased overtime, increased workload, and ultimately a reduction in the length of stay of patients will be prevalent. Having medical staff suffering from psychiatric injury due to lack of policies and procedures puts the healthcare system into a negative spiral. Beginning with career changes, time off work for prolonged mental sick leave ultimately puts increased workload and increase in overtime hours onto remaining staff, which, considering the nature and high stress of the industry, exposes remaining staff to psychological injury themselves. Increased workload and overtime due to understaffing not only affects the performance of the medical staff, for example their lack of cognitive functions, which may lead to error. Less time spent with patients or less services required may contribute to a decline in patient care and satisfaction and creates a possibility that patients are required to return to the hospital.
Thank you, Dr. Lammers. I will now introduce some reforms and recommendations that we have made on behalf of the Australian Medical Association. In an experiment conducted by psychologists in which one group of subjects were required to relive emotional pain and another group of subjects were required to relive physical pain, research collected from Purdue University and Macquarie University has shown that participants in the emotional pain condition reported higher levels of pain than participants in the physical pain condition. This is because, while both categories of pain can be extremely hurtful at the time of happening, emotional or psychological pain has the ability of sticking in the mind and consistently affects the person who has experienced it, as opposed to physical pain, which usually only hurts at the time of occurrence. Thus, psychological pain is more detrimental to the daily life of a person, as treatment methods are more difficult to identify and recovery processes are lengthier. In actual fact, psychological illness is likely just as disabling to workers in the medical industry as physical illness is, if not more. Therefore, reformation of the Workers' Compensation and Rehabilitation Act and the Civil Liability Act is vital to protect the interests of the medical professionals that dedicate their lives of helping and ensuring the well-being of the Australian public.
The current legislation relating to compensation for psychological damage suffered as a result of the workplace is the Civil Liability Act and the Workers' Compensation and Rehabilitation Act. There is room for reform in both of these acts because neither provides a specific definition of mental disorders as personal injury. Part 3 of the New South Wales Civil Liability Act covers the claim of damages of mental harm. Section 29 provides that in any action for personal injury, the plaintiff is not prevented from recovering damages merely because the personal injury arose wholly or in part from mental or nervous shock. However, the legislation does not define the phrase mental or nervous shock, so it leaves it open to interpretation of what constitutes as mental or nervous shock and what it requires. Section 30 outlines that the plaintiff has to witness at the scene the victim being killed, injured, or put in peril, or the plaintiff must be a close member of family of the victim to be able to recover damages. This part of the legislation therefore discounts the stress that can be suffered by medical professionals while on the job. Section 32 of the Workers' Compensation and Rehabilitation Act defines injury as psychiatric or psychologic injury that is suffered as a result of the job. However, it does not adequately define what is considered psychologic or psychiatric harm, just that it has to be caused from more than the general stress of the job.
In Whitson State Rail Authority and Sheehan State Rail Authority, 2 police officers, who were the first to arrive at a scene where a train derailed, witnessed horrific scenes such as dismembered bodies, which consequently led to them developing post-traumatic stress disorder. They respectively sued the State Rail Authority for their psychological damage suffered. They were granted compensation in an appeal brought towards the High Court for the sudden shock. This is because it was found that the Court of Appeal was wrong to assume that all cases of death, injury and peril begin and end in an instant. So the train passengers could still be in situations of peril after the initial derailment, like when they were extracted from the wreckage, which the police officers witnessed. In medical situations, patients are often brought in from incidents with grave injuries, and their peril does not end at their initial impact. Many times, medical professionals, like emergency medical technicians, have to perform CPR at the scene of the incident and witness victims suffering. Surgeons in the emergency room see patients in continual suffering, which is sometimes elevated as the medical procedure is conducted. Therefore, medical professionals witness victims still in their journey of peril on a recurrent day-to-day basis. They can also be seriously distressed by the severity and the frequency of the scenes. Therefore, the legislation must be amended to include first response rescuers in the requirements to claim damages for mental harm and nervous shock.
Currently, tort negligence law is quite heavily skewed by the narrow male norms of determining whether the defendant has a duty and whether they have met the basic legally required standard of care of the plaintiff. It is also heavily based on the concept of reasonableness, on whether a person fits the criteria of having reasonable judgment under similar circumstances of an ordinarily prudent person. However, the standard of a reasonable person is allegedly objective rather than subjective, because the so-called established universally applicable measure for conduct will not be the most efficient in different contexts. A feminist critique of tort law challenges whether the law would be better with the inclusion of the ethic of care and concern. The feminist perspective incorporates the feminist ethic of care and concern as a basis for the standard of care that employers should take with their employees. The question is raised of how careful should an employer be to prevent negligent harm being caused to their employees? The question is answered by the idea that the basic standard of care should be the employer's consideration of their employees' safety and interests. It focuses more on the prevention of psychological illnesses that stem from the workplace even coming into fruition in the first place.
Although the Workers' Compensation and Rehabilitation Act and the Civil Liability Act do not recognise undiagnosed psychological damage, such as mental harm caused by constant stress and shock in the workplace as an injury, if these conditions are left unattended to, they may develop into more serious, permanent impairments. This is where the feminist approach of care and concern is needed to prevent a profession from being the primary root of mental health problems. Medical professionals, especially ones working in emergency or surgical departments, suffer from great stress as they are frequently present at scenes that are often gruesome and violent or operate in life or death situations. In addition to this, witnessing the distress of patients' families or being the subject of abuse from concerned next of kin can heighten the psychological effects of their already stressful occupation. In the Brown and Maurice Blackburn case, it was ruled by the Court of Appeal in Victoria that an employer at a law firm owes a duty of care to lawyers that are working at its firm in taking reasonable care to avoid exposing them to unnecessary risks of injury, such as workplace bullying. This is an example of the application of a feminist school of thought and taking someone's best interests into consideration and not just imposing the legal standard of care. Even though it is general knowledge that medical professionals, such as surgeons and emergency medical technicians, will be at risk of being psychologically influenced from the stressful situations that they encounter while carrying out their day-to-day activities, such as arriving at confronting crime scenes or having to operate under obligatory urgent conditions, other factors or unnecessary risks that can contribute to psychological harm, such as verbal abuse from the patient's friends or family, should not be grouped under the same risk category as the former. Also, in cases such as Haggerty and Queensland Ambulance Service and State of New South Wales and Donnelly, psychological trauma suffered from the profession is addressed, with the former case failing for the plaintiff and the latter succeeding. Haggerty concluded that the employer was not liable for the mental harm suffered by the plaintiff over a number of years, because the plaintiff was a highly experienced and well-regarded police officer, so it would have been unnecessary and inappropriate for a supervisor to suggest that the plaintiff should seek psychological assessment. Since the plaintiff had requested to be transferred to a different department several times during his years of service, if the feminist approach of care and consideration for others' safety had been applied, the outcome may have been different, as the employer could have expressed concern about the plaintiff's repeated attempts to transfer. In Doherty, it was held that the nature of the work performed by crime scene police officers was so intense as to require the employer to impose a high standard of monitoring of such officers. So, independent psychologist or psychiatric testing would have had to be conducted. This outcome mirrors the feminist ethic of employers genuinely caring about the well-being of their employees and should be implemented in the medical industry, as medical professionals suffer an equal amount of stress to workers in the police force.
Therefore, we propose that the Civil Liability Act and the Workers' Compensation and Rehabilitation Act be amended to specify undiagnosed psychiatric and psychologic disorders that can arise from the workplace. Section 30 of the Civil Liability Act should be modified to indicate that death, injury, and peril can extend to longer than just the moment of the incident. This will allow many more workers to receive compensation for mental harm, especially emergency medical technicians who arrive at the scene of the accident, and emergency room surgeons who commonly operate not long after. We also recommend that the law implements the feminist approach To do this, seminars can be held or information packs can be sent out to medical institutions to educate employers of the concept of care and concern that they can implement into their workplaces. This will allow employees to feel more comfortable speaking up about any work-related mental health concerns that they may have and prevent such concerns from turning into more severe illnesses. It will also encourage employers to look out for their employees and may aid in spotting any abnormalities in their psychologic behavior. We also propose the introduction of regular mandatory psychiatric assessment for medical professionals working in scientifically proven, high-stress and demand occupations. This way, since it is mandatory, it will not be inappropriate to suggest that a highly respected surgeon be psychologically tested. Current legislation within Queensland jurisdiction limits the scope of liability upon an employer in relation to psychiatric injury. Breach to a duty of care owed by an employer to an employee within the medical profession continues to operate within the aforementioned limited scope of liability in regard to psychiatric harm. This leads to increased levels of distress and mental illnesses in the medical industry. In the long term, this will thereby affect the number of medical staff available to provide a stable healthcare system, especially in high-stress departments. Reform of the current law is required, as mental health of the medical professionals in the industry is so overlooked. This is definitely necessary so we can protect the people that protect us.